All right. So I hope you guys can see my slides. All right. So for my part, I'll be discussing the legal considerations that should be considered by the project owner and by the legal team for both the vendor and the client when entering into contracts for certain IT projects. All right. So this presentation assumes that your organization has a need for certain pieces of technology or certain IT software, or it could also be the case that you are the entity providing such software. So IT projects and IT arrangements could involve various types of contracts and various types of arrangements. It could involve an instance where you just need a software license. It could involve software development projects where you need customized IT products built from scratch, specific for your organizations and to address your needs. It could also be that you need a service provider for systems integration, and this would involve a bunch of arrangements. It could involve off-the-shelf software. It could also involve a bit of customization. And then, of course, you may also have a need for support and maintenance services for your IT products. So we won't go through it one by one, but the goal of this presentation is to highlight or to zero in on certain provisions that you will need to carefully consider when going through the negotiations. So even before you get to the point of actually negotiating a contract, we assume that you've already gone through certain stages of like assessing your need for an IT product, assessing your considerations in terms of costing and in terms of timelines. So knowing these factors, those flashed in the screen, would be important in guiding your team in the software or the service negotiation stage. So for the scope of work, your team would have to identify whether you actually need to build something from scratch or you can get something that's off the shelf. Whether the service that you need would come from just one supplier or will it come from multiple suppliers? Will you need maintenance services for that piece of software? And then for timeline, you need to consider where your IT project would stand in reference to other components of your bigger project. The reason would be you should know or you should identify if it's a dependency for other things, so that if you're sensitive as to deadlines, as to timeline, then you can consider putting in provisions that would disincentivize your provider from delay or from other failures, and then of course cost. All right, now, so let's say that you have identified that your organization needs a certain piece of software for either for your product or for your internal processes. So let's say that you've identified that you need something from scratch or something customized. So it's important to put into writing what those deliverables are. If this is software, the desired functionalities should be specified in your contract. So it's important that your legal team and your tech team work and communicate effectively. And then, of course, deadlines should be specified. So in terms of methodology, one of our panelists would be discussing this more closely, maybe later or during the discussion. It usually takes two forms. Either you set up your deliverables or you specify it through like a waterfall method where you identify specific milestones, or you do agile. So for contracts, it's simpler if you can implement a waterfall method. So this would refer to instances where you can divvy up or you can divide your IT development project into certain milestones that could be clearly identified. So in the screen that I'm flashing, I've copied a portion of one of our contracts. This would refer to the milestone annex. So ideally, your team should be able to identify the milestone. So that's the portion, that's a highlighted portion. And then ideally also, you should have your provider commit to certain deadlines. Okay, so let's say, so here, so column 1 would be the milestone, and column 2 would be the deadline when they should present that piece of the project component. And then third column would refer to the payments that would be due in terms after the milestone is completed. Okay, so it's important, especially if you're sensitive as to cost, that you insert acceptance test provisions into your contract. So here, similar to what's flashed in this page, we should specify the criteria that would guide both parties in determining whether a certain deliverable conforms or doesn't conform to specifications. We should set presentation deadlines. And then again, also, you should also set mechanisms that would guide both parties in the acceptance test. So let's say milestone A is presented to the client, and for the client, it fails to conform to an agreed upon specification. It's best that the parties are given deadlines. Let's say after presentation, the client would have 5 days or 10 days to test the project. And if the client observes certain errors or certain bugs in the software, then the client should be able to show and demonstrate why that's a non-conformity. And then, of course, the contract should obligate the provider to remedy such defect or the bug, provided it's demonstrable. The provider should be obligated to remediate the non-conforming aspects. Okay. Then a note on change orders. As noted, diba in the first page, one of the most important aspects of your software contract would be your ability to clearly state the functionalities. So now, in the stage of the development, if let's say the client suddenly changes its mind and wants to change a certain aspect of the project, your contract should contain a provision on change orders such that a change in the specifications should not be binding on the provider if both parties did not agree on the change. So this is important in terms of preventing scope creep, where your project ends up covering certain aspects that none of you intended, thus leading to either over budgeting or missing deadlines and missing set timelines. So the change order should take into should enable the provider, if you're the provider, to adjust the cost and adjust deadlines, and thus prevent possible events of breach. All right. Now, for certain systems integration arrangements where the project would involve maybe some licensing of third-party software or your own software, and then some customization or some development. So the pieces composing your project should be specified. So if ABC would refer to the obligation of the provider to give you with software licenses, that should be clear, and the functionalities for each software license should be clear, like what's the extent of rights that the license would give you. Can you use the software anywhere in the world, or is it limited to, let's say, the Philippines? Can you use the software? Can you sub-license the software further to your affiliates or to your subsidiaries, or is it limited to your entity? So that should be specified there. And then, is it limited to a certain number of authorized users? So this is important if, for example, you will need your entire team to use or to be an authorized user of a specific software, then that should be taken into consideration. All right. So now this is a tricky aspect of some contracts. Like, let's say you're engaging a tech provider to provide you with a crucial piece of technology. However, 90% of the software being provided to you is given or is actually being provided by another third party, like a subcontractor of your direct provider. Then if you want to be strict about it, your contract should allocate responsibility. So by default, if I'm the provider and I'm providing you with third-party software, it's in my interest to disclaim responsibility over all of these third-party software, right? Like I disclaim responsibility over defects arising from the third-party software. I disclaim responsibility over infringement allegations arising from those third-party products. So if you're on the other end of the table and you're the customer, it's in your interest to obligate your provider to be or to hold your provider responsible for these third-party products. So in terms of drafting the contract, you should consider where you stand. And then another thing, in terms of support and maintenance, of course, so that also goes into, it works the same way. If you're the customer, you should see to it that the warranties provided by your provider extends to the third-party products, right? Especially if a bulk of the project would actually depend on those third-party products. So now if there's a general disclaimer over all of it, then your contract really does nothing to protect your interest if you're the customer. And then of course, the contract should also be able to specify what systems or deliverables are the responsibilities of the client. So in a software arrangement, this would usually refer to, let's say, the hardware or the necessary infrastructure. That's usually the responsibility of the client. Now, this provision would be crucial when, let's say, there are certain hardware requirements necessary for integration. So let's say the software would require certain minimum system requirements. It should be stated here. So in case the software fails to be integrated into the client's system, it would be clear. It would be easy for the parties to determine whether that failure to integrate is because of the failure of the client to comply with set system requirements, or if it's the failure of the provider to provide the correct system requirements. All right, now a note on open source software. All right, there are certain cases, like let's say for like e-commerce websites. If you're a provider of an e-commerce development, if you provide development services for e-commerce platforms, you may be using certain modules that are covered by open source licenses. So this is okay, but if you're the client, part of your diligence in scoping out the ability of your provider should be in finding out whether their service or their software would include open source software. So why is this important? It's important in assessing the ability of the provider in providing warranties and disclaimers over the software. So usually open source software would already come with baked-in license provisions, which the user, or in this case, the provider and the user would be bound to follow. So this would affect the ability of the provider to, let's say, transfer rights over the components involving open source software. It may also affect the ability of the end user, the end client, to use that software. Like let's say if there are limitations, you're automatically bound by the open source license limitations. And then also another note on open source software. Most of the license provisions for open source software would require the user to, so they can use it for free, right? But in exchange, the developer that incorporated the open source software would have to disclose the resulting product which incorporated the open source software. Now, if you're sensitive about like the secrecy of your code, etc., then this is something you have to watch out for. All right, now for warranty clauses. When lawyers review service software contracts, like license contracts, development contracts, a warranty clause such as the one flashed in the screen is something, is a usual template provision. So in this example, it states that the provider makes no warranty or representation, express or implied, including but in no way limited to warranty as to quality, condition, merchantability, suitability, or fitness for a particular purpose. In some instances, the warranty on non-infringement would also be disclaimed. So when you're talking to a lawyer for the provider, they would say that this is a standard provision. We can't edit it. It's standard for software contracts. However, that's not exactly true. So if you're the customer and you have some sort of negotiations leverage, the diligent thing would be to carefully carve out this provision. So if you're buying a piece of software off the shelf, something like this could be acceptable. But if you've engaged a provider to provide you with customized solutions from scratch, then you may have some negotiation leverage to demand, let's say, that they warrant that the software will function consistent with what they've marketed to you. They can warrant that the code is not infringing, for example. So the best way, again, is to carve each and every phrase here and to not accept a blanket disclaimer on warranties. And then another thing to consider when providing warranty clauses, if you're the provider and your client wants you to warrant that the software will function a certain way, that the software is non-infringing, etc., and that any breach of warranty will obligate you to remedy the same, then you should consider whether your own product as the provider is actually dependent on third-party products, if that makes sense. So let's say your software would the whether or not your software will work will depend on the support that you get from a third-party maintenance provider. Then if you're making a warranty that the software you're providing will function, let's say, 99% of the time, then your maintenance agreement with your third-party provider should contain some sort of mirror provision that would actually allow you to comply with your obligations to your end client. Okay. Another provision to consider would be provisions that are aimed at controlling or at disincentivizing delay. So usually we encourage putting in delay penalties if you're the client. And if your provider is confident that they can deliver on a certain date, then you should negotiate provisions that say for every day of delay, you can charge a certain amount of penalty. And then if you're the provider and you want to limit that liability, then you can agree on a cap. Like, let's say the delay should be no more than 10% of the total fees, etc. And then another provision alongside delay penalties would be a provision that would allow the client to engage an alternative service provider if the main provider commits a breach or fails to deliver on time. And then, of course, the right to be able to, if you're the client, you'd want the right to be able to terminate in case of any delay. And it's also in your interest to say that the remedies are cumulative and not alternative. Meaning, if you pick one, then that should not prejudice your right to let's say, to terminate or to exercise the other remedies available under the contract and available under law. So this is crucial because sometimes providers in their template contracts, they would say that the act of the client of picking one remedy, let's say the client already exercised its right to collect delay penalties, would eliminate the right of the client to, let's say, terminate the contract or go after the provider for breach. So just watch out for that. And again, for intellectual property, so just check if the provisions are consistent with the commercial arrangements that you've discussed with your provider. So if the developer who built out your system warrants that you should own the system after, then that should be in your IP section. And then in terms of source code and documentation, if both the parties agreed that the source code would be transferred to the client, then that should be baked in as well. Although sometimes getting the source code would, in reality, really do nothing for the client, since it's not like the source code will be understandable. It's not like there's a universal language that all developers could understand. So sometimes you have the source code, but the provider breached, and then even if you have the source code, you're still left with a piece of software that you can't use. So there, which is actually where the maintenance provisions of a contract comes into play. Because most of the time, the only party that could actually maintain your software would also be the party that developed it. All right. So same thing with the delay. Again, in case of infringement, if you're a client, it's okay if the types of remedies in case of infringement are spelled out in the contract. However, again, you should include the provision stating that it should be your choice as to what remediation measure the provider should take. And those remedies, again, should be cumulative and not stated in the alternative. For termination, what's crucial? The crucial thing here is if you're the client receiving the software product or the software services, ideally you should limit the ability to terminate to yourself, meaning you don't give the provider the chance to terminate the contract, at least not for convenience. The reason is if you give your provider the right to terminate, you may be stuck in a situation where, let's say, you're months into the project and then suddenly your provider terminates, right? Now, even if you can engage, theoretically you can engage another provider, it will be difficult for another provider to come in and try to make sense of a semi-built software. It's not like, let's say, construction, that it's obvious what you need to do. With software development, you may not be able to continue where the first provider ended, and you might end up just starting from scratch. So now again, if your IT project is a dependency for a bigger project, this would cause substantial delays and probably cost. So again, just limit the right to terminate to yourself. At most, you can probably allow your provider to terminate in case of breach, which in the case of, if you're the customer, probably the only breach that you'll be able to be faulted for would be failure to pay, for example. Okay. Now for maintenance, why is this important? This is important because, of course, if you have a piece of software, more likely than not, it would break down every once in a while, or there'll be bugs or errors. And as I mentioned, even if you have the source code, it's likely that the only team that could understand that that source code is the team that developed it. So you may end up having to negotiate another maintenance agreement. And actually, sometimes developers make more money providing support and maintenance than in providing the initial development services. So what should you watch out for? Watch out for inclusions and exclusions. If you're the provider, then most likely you'd want to exclude, let's say, defects arising from the acts of third parties, or defects arising from the willful misconduct of the customer mismo, or defects arising from unauthorized combination of the software, installation that's not consistent with your instructions, etc. And then, of course, if you're the customer, you'd want less exclusions. And then also for support of third-party products, as mentioned a while ago, usually in the default contracts, support for third-party products are excluded. So again, if the third-party products are crucial to the functioning of the entire system, and you're the customer, you should look for a way and try to negotiate that this be covered. And then, of course, SLA should be there. This would refer to the escalation mechanisms, how you make a complaint, how you request for support, etc. Most of the time, you should be able to require your provider to commit that the software will be fully functioning, let's say 97% of the time. And then if that piece of software fails to perform as committed, then you may want to ask for the right to collect rebates or right to collect penalties. And then again, our note on remedies comes into play here. So if you're the customer, you should see to it that even if you collect for rebates, demand for refunds, etc., or penalties, you should see to it that this will not affect your right and ability to go after the provider for or to exercise other rights arising again from the contract and from law. Yeah. So what you want to avoid is a situation wherein, so you already have the software, but it ends up not being, it ends up not performing according to what you've expected. And then the provider would just give you rebates for it. However, if it's a 5-year contract, then you're stuck with your provider for 5 years. And it'll be difficult for you to get out of it, since the rebate clause could have been worded in such a way that it's your exclusive remedy in case of software failures. All right, now for other terms, just quickly, these are usually captioned in the contract as, like, let's say, general terms or miscellaneous provisions, and maybe some lawyers have the tendency of just ignoring these provisions, thinking that these are boilerplate templates. However, these are also important. Like, for example, the entire agreement clause. This clause essentially says that the written contract contains the parties' agreement, the parties' entire agreement about the subject, which is the software services, and supersedes all oral or written agreements made between the parties. So this is crucial, since sometimes the project proponent from the client side usually speaks to a salesperson from the provider. And salespeople have the tendency of over-promising or over-committing, saying that everything's possible. But then once you have the written contract, you find out that the provider actually disclaimed everything, and you can't hold the provider to certain warranties. And since you've signed off on a contract that says the written agreement is your entire agreement, you can't go after the provider for the stuff committed by, let's say, the salesperson or any other party. That's not baked into the agreement. And then for dispute resolution, essentially you agree whether you want to go to court or whether you want to limit the ability of parties to settle disputes via arbitration. For governing law, if you're dealing with foreign providers, then you may want to ensure that the contract is actually governed by Philippine law and not foreign law, in which case you may have to hire foreign counsel and advisors for that. And another provision would be assignability. So this refers to the right of the parties to assign obligations or rights arising from the contract. Now, if you're the client, you may want to, and you chose the provider for a specific reason. Let's say the provider is credible, the provider has a good history of providing software products. Then you may want to make sure that the obligations there would be done by the provider. So you'd want to limit the provider's ability to assign any of its obligations to a third party. All right, so from my end, that's it. If you